folks. I guess we'll get started. Thanks for coming.
Thank you for coming.
No, I think it's okay, Jen.
Yeah.
Everybody can see, right? And you have the material?
Yeah, absolutely.
Okay. Okay. Okay, I'm Don Vanarelli. I'm gonna go through these 4 topics, okay? How's that? Better?
Always.
Okay. Trying to take a film of this too. My first time. We'll see how it comes out. Okay. Feel free to ask questions as we go through, okay? Okay, so planning for disability. We're getting older. Sometimes you lose your mobility. What are some of the issues you may face in this situation? Okay, what kind of arrangements can be made for substitute decision making? When you can't make decisions anymore, what's out there available to people? And they basically fall into 2 groups, where you have to go outside of yourself. You can't make voluntary arrangements. So voluntary arrangements is number 1 and preferable. Then there's court-ordered arrangements. The court imposed substitute decision-making in New Jersey are guardianships and conservatorships. That's it. And most of the time we're doing guardianships because guardianships are for people who can't make decisions for themselves. They're incapacitated and unable to handle their affairs. So a guardianship is, it's a legal arrangement whereby a court directs that somebody take over for the incapacitated or incompetent person. These are some of the characteristics. So since it's imposed by a court, it's involuntary. Nobody says, I consent, because the whole thought is that you're not able to consent anymore. You don't have the capacity to consent.
And where do they find these people that are going to be guardianship?
Well, usually, where do people come from who apply to be guardians? It's usually loved ones. It might be a husband for a wife, wife for a husband, the children for, usually family members are applying to be guardian for other family members.
And if there isn't any, what does the court do then?
The court can order that there's a state agency in New Jersey, the Office of the Public Guardian, that they have thousands of people that really they deal with. So the public guardian is for people who are over age 65, who don't have any family members who can step in. So they handle paying the bills, making sure people are receiving the appropriate care, etc.
And they have to pass the test, or they have to pass some type of qualification?
Who?
The people who are going to be the guardians.
No, they just have to be, family. There's a preference for family.
No, but we're speaking about no family.
Well, then the agency has been set up to handle it. So no, there is no test. Okay. All right, so that's the situation where, you haven't made voluntary arrangements, but there's a whole plethora of voluntary arrangements. Like, for example, you may have heard of this, you can get a representative payee for Social Security benefits. You have to go to the Social Security office and apply, and instead of the person who, worked and earned the money to getting the check themselves, they'll send the check to you as a representative payee, and you'll be in charge of it. That's one thing, you see that a lot. During tenancies, you don't think of this as being a substitute decision making, but if you put a child's name, for example, on a bank account, on a real estate, right? Then that person becomes a joint owner with you, and you can't do things except if they consent. Power of attorney, a real common thing, where you as the principal are appointing somebody else to handle your financial affairs, and you have a list of things that they can do in the document. Advanced Medical Directive or living will, where you list the type of medical care you'd like to have if you become you're unconscious, you're in a coma, you have an incurable disease, you can't make decisions, and then you appoint a proxy to make decisions for you. Do not resuscitate orders, DNRs, where in certain situations your lungs stop breathing, your heart stops beating, you told the medical provider, don't resuscitate me, no cardiopulmonary resuscitation permitted. Revocable and irrevocable trusts, that's another way of setting up your assets. You put money, assets, real estate into a trust, and then somebody else is handling the management of those assets that are in the trust. Or different things like family limited partnerships or limited liabilities companies. These are all entities that are set up that people use basically for estate planning purposes. Okay, so these are, since powers of attorney are so common, I like to cover those because even though they're common, a lot of people don't have them. They're usually a good idea to pick out the person who you want to handle your affairs. You as the principal appoint somebody to be in charge when you can't handle your affairs. And let's see. Okay. These are some of the characteristics on the slide. It creates a relationship between the two of you. Like if I appoint my wife as my power of attorney, or I appoint a friend as a power of attorney, you have the agent, the power of attorney, has a duty to handle my affairs with my best interests in mind. That's a legal duty that they have. You can have a general power of attorney. That's what most people have. You can do all kinds of things, or you can do a special power of attorney. Like if you're appointing somebody to handle a real estate closing, you just say, okay, you can only do that, nothing else. You can have a durable power of attorney. You hear that most of all, where you sign the power of attorney today, and it's effective from today until you pass away. Or a springing power of attorney, you can also sign that, where you sign it today, but it's not effective until you become disabled, and then it's set to spring to life upon your disability, and then they can handle your affairs. You can appoint, like a lot of people come in the office, they have 2 or 3 children, they want one child to be the agent, or they want all 3 children to be the agent, and either way is acceptable. And then the power of attorney, unless otherwise stated in the document, is going to terminate on your death. But you can have it terminate whenever you can revoke it in advance of death if you want to. Okay? And I just gave a list of some of the powers that you can list in the power of attorney. And in New Jersey, you only have the powers that are listed in the document. There isn't anything else. Like some states have laws where they give you separate powers, even if it's not in the document. That's not our state. So here's some of them. Banking transactions, or do you want to make gifts, or if you want to create and fund trusts, or change beneficiary designations, things like that. So you try to be as flexible as possible and include as much as you can to make sure that people, can do the things that they want to do. Okay, advanced medical directives or living will. If you are unable to make medical decisions, you need a proxy in there. You need an agent to make the decisions for you. And this is one way that you do it. In New Jersey, you have you can sign any one of these, or you can sign all of them. In other words, we have an instruction directive where you say, if I'm in a certain situation, like if I'm in a coma, have an incurable disease, don't give me cardiopulmonary resuscitation. You give instructions on how you want to be treated in certain situations. And then a proxy directive, which we also can do, is where you actually appoint an agent to handle your medical affairs when you can't handle them anymore. Most of the time we do a combined directive where you give instructions, try to help the agent along what you would decide, and then you appoint an agent to make those decisions. Okay?
Do you have to have an agent?
You can usually, usually a good idea to appoint an
And
agent.
if you don't?
If you don't, and there's decisions to be made, right? Usually the hospital the hospital gives advice. The doctors are telling, I think you should do this or that. There's nobody there. A lot of times the hospitals will go to court to get a guardian appointed quickly to make a decision regarding medical care, because they're not really permitted to make decisions. Okay, good to have the stuff set up. A good friend, could be anybody really, but better than, if you go to court, anybody who doesn't know you, usually an attorney is going to be appointed, has to conduct an investigation and make a decision, and it may be a decision that you would never have made, but the person you're a stranger to that person. Okay, DNR orders. I think I covered this a little bit. This is to tell the medical providers that you don't want cardiopulmonary resuscitation. It's really an end-of-life type situation. Usually these are signed when somebody has an incurable disease, or they're suffering from dementia or Alzheimer's disease. They could be brought back from situations where their heart stops beating, but there's no quality of life, so you make a decision that you don't want these extraordinary measures imposed. This is something new that came out, this POLST order, a practitioner order for life-sustaining treatment. It's a way to ensure that your wishes are carried out, because you have talked it over with your doctors, with your loved ones, you've decided the type of care that you want, and you sign an order, and the doctors sign it, that indicates the type of care that you're supposed to get. See, with the Advanced Medical Directive, there's always a situation where doctors have to agree. They do get a say in what's going on, because maybe the type of care that's wanted is not really what the doctor would recommend. So they make it contingent on what doctors are saying. But this kind of thing you can sign, and it's a doctor order that's entered in advance, where you can ensure that the care that you want is definitely going to be provided for. And I indicated some of the characteristics of the POLST form. It's pretty new directive that we're allowed to sign. And here's a psychiatric advanced directive, again, a new type of form that you can sign, that you can express your wishes. If there's some kind of mental breakdown, mental issue, you can indicate the type of care that you would want, and who is going to make decisions regarding that care. It's all for appointing a substitute decision maker in advance, so that you can be assured that the people that know you the best are going to make decisions about you. That's what it's all about. Otherwise, the decisions have to be made. And if you don't appoint somebody else is going to be appointed, and going to be making recommendations to the court, and you may not have agreed with it. Okay? Any questions? Okay. So, trust. I'm trying to go down that list that I started with, showing you different substitute decision-making vehicles that you can use. So a trust is, it's an important type of estate planning tool. And it's really, we think of a trust as a document. We've prepared a trust, and you're signing it, and you're going to put money into the trust, or you're going to put assets into the trust, and the trustee has to do what you say. But really, when you appoint somebody as a trustee, you're creating, they call it a fiduciary relationship with the person. It's really a relationship creator, where you are appointing somebody who takes on the task of performing the duties set forth in the document, so that he or she is supposed to act in your best interest. So, you say what you want to happen, but the person is empowered and really obligated to act so that your wishes as expressed are carried out in the best way. And that's really what it's all about. Okay, and I just included this because this is a special type of trust. And it comes up a lot when you have disabled children. It's a super helpful trust, very useful in that you can set up a trust for a disabled child or a disabled person. And you can transfer assets to these trusts. They're called special needs trusts. And a person can have a trust fund and still be getting government benefits based on financial need. Like most of the time, if you're eligible for SSI or food stamps or Medicaid, you know, these are they're based on your medical needs. You have to have be unable to perform certain activities of daily living. So you have to be ill, and you have to be, you know, have very low income and resources. But here's a way where you can qualify for Medicaid. Medicaid pays for a lot of different medical care for people who are disabled in facilities, etc. You can qualify for Medicaid, and you can still have a trust fund if it's set up in a special needs trust, so that you can improve the quality of life of the disabled person. Because Medicaid only pays for medical care. It'll pay for room and board. Any other things that you may want to do, it's not going to supply. If you would like to have a computer, it doesn't pay for the computer. If you want a TV set, if you would like to occasionally go out of the facility and stay overnight somewhere, you know, none of those things are covered. So to improve the quality of life, this type of trust was permitted under the Medicaid laws, so you can supplement your public benefits. So, you know, you can provide for people who are disabled, and they're not going to lose their Medicaid, which is usually the critical one. But any kind of government benefit based on financial need, you could, like Section 8 housing, you can be sure that the person would stay eligible and have a trust fund. Okay, so that's my presentation on planning for disability. Do you have any questions? Okay, feel free to ask.